A very good evening, ladies and gentlemen. Welcome to Bangunan Sulaiman. As you can see, it's an earlier time slot because of the fasting month of Ramadan. And thank you for joining us. Today's talk is titled Arbitrating in Asia, the Good, the Bad, and the Ugly. And to take us through this evening, we've got two learned personalities with us. The talk will be delivered by Peter Goodwin and will be moderated by Lam Wai Lun. A brief introduction about your moderator before I hand over the floor. Lam Wai Lun is a partner of Mercer's Harrell and Lam Partnership. He sits as an arbitrator and is a qualified adjudicator to adjudicate disputes under the Construction Industry Payment and Adjudication Act 2012. Wai Lun is the current chairman of the Chartered Institute of Arbitrators Malaysia branch, deputy president of the Society of Construction Law Malaysia, and the vice president of the Malaysian Society of Adjudicators. Without much ado, can we please put our hands together for Lam Wai Lun?
Thank you, Franz. First of all, thanks, special thanks to Peter Godwin for taking his time and trouble to share his experience about arbitration in Asia with all of us today. Just a brief introduction about Mr. Godwin. Mr. Godwin is the managing director of Herbert Smith Freehill's Tokyo office and head of the firm's dispute resolution practice in Asia, with extensive experience in arbitration, litigation, and other forms of dispute resolution. Peter has been practicing in Japan for over 15 years. Peter is considered a leading figure in Japan for arbitration and is highly regarded within the market. Independent legal directories have described him as a dispute guru in the Who's Who Legal publication, a real expert in dispute resolution and a superstar of the Japanese dispute resolution space in the Chambers Asia Pacific publication. He is ranked in the top tier for dispute resolution in Japan by both Chambers Asia Pacific and Asia Pacific Legal 500. Peter has recent experience representing clients under ICC, LCIA, HKIAC, SIAC, TAI, JCAA, UNCITRAL, and ad hoc rules. He has represented clients in numerous arbitral centers around the world, including in London, Paris, New York, Stockholm, Oslo, Tokyo, Bangkok, Mumbai, Hong Kong, and Singapore in disputes under English and other common and civil law systems. He also sits as an arbitrator and has recent experience under both ICC and JCAA rules. He is qualified as a solicitor in England and Wales and Hong Kong, and is licensed to advise in Japan as a Gaiko Kuho Jimu Bengoshi. I need you to explain what that term means. Let's put our hands together for Mr. Godwin. Thanks.
Thank you very much, and thank you for coming out on what's, I suppose for KL, a typically warm, hot and sweaty afternoon. I'm very much enjoying the air conditioning. Arbitration in Asia, the Good, the Bad and the Ugly, was a title designed to attract an audience, because I don't suppose you know what it means, and I'm not sure I quite know what it means, but it's really just an excuse for me to share some of my experience over the last 20 years of doing this work in Asia, and to tell you a few war stories, because I always think the stories and the practical insights are far more interesting than the law. Strange thing for a lawyer to say, but hey-ho. So what I could have called it is mistakes that undermine the advantages of arbitration, but that just seemed a bit duller, and not so many of you might have turned up. But before I get into the stories, I know there's a number of people in the room who are very experienced in the world of arbitration, and you understand why clients go to arbitration rather than litigation. But I think it's worth spending just a couple of minutes reminding ourselves of that, because the stories that follow are very much linked to those advantages and how poor lawyering can undermine those advantages in a very substantial way. So what are those advantages? Enforceability. The New York Convention means arbitration awards are readily enforceable, at least in theory, in most places in Asia, the exceptions being Taiwan and North Korea, but I guess we don't need to worry too much about those. Taiwan, there are other means available. North Korea, there's not too much business being done just at the minute. They're too busy firing missiles at us. So enforceability is important, and by contrast, court judgments are very difficult to enforce. You take a court judgment to Indonesia, for example, you can't enforce it. Now, you might be sitting there thinking, oh, that's because Indonesia is desperately corrupt. It's not. It's because the law doesn't recognise or enforce any foreign judgment from anywhere in the world. Whereas an arbitration award, at least in theory, is enforceable in Indonesia. So there, if you have problems, maybe you are stumbling across corruption rather than the law. So that's one important advantage, which we'll come back to. Neutral forum and law, allowing parties to choose places they want to go and resolve their disputes. Very useful in cross-border transactions where nobody wants to allow the other side to have home advantage. If a Malaysian company is contracting with a Japanese, as a Malaysian company, you're not going to want to go to Tokyo to resolve your dispute. As a Japanese company, you're unlikely to want to come to KL. So you can agree to go to probably Singapore in that instance would be the likely choice. A neutral venue, that's important. Just stopping there briefly, and I'll come back to this phrase, finger-pointing arbitration clauses. I don't know if any of you know what those are. If you don't learn, because my advice is don't use them. They're fantastic for me. They make me a lot of money. They waste clients' time, they waste clients' money. They're a horrible compromise that cause jurisdictional and other issues and should not, in my humble opinion, be used ever. But I will say more about those later. Party autonomy and procedural flexibility, a key advantage of arbitration, should certainly lead to efficiency, allows you to arbitrate in a language that you can agree. So if you're dealing with a Japanese company, rather than go to a Japanese court and have to deal with in Japanese, you can go to, if you agree to go and arbitrate in Tokyo, you can at least do it in English. Sounds like a minor advantage, actually is a major advantage. The cost alone of translating and interpreting is one of the biggest costs in international arbitration. Translators and interpreters make people like me look reasonably cheap. I know you will find that hard to believe, but it's true. It also allows you to choose your own arbitrator. That's important. Choosing an experienced arbitrator who understands your case can influence the outcome of your case. If you choose the right arbitrator, I genuinely believe you can entirely legitimately, playing within the rules of the game, influence the outcome of your case. Not enough time is spent on choosing your arbitrator. And again, I will be coming back to that. Confidentiality. People like the idea that arbitration is confidential. Again, I'll be coming back to this one. But just ask yourself the question, when is arbitration confidential? Is it always confidential? The fact that I'm asking you those questions will hint that the answer is not always yes. And I'll give you an example just to reinforce that shortly. But we've been talking a lot about law now. 90 seconds is about as long as I can normally do on the law without a story, so let's have a story. Confidentiality versus privacy, a very important distinction. Arbitration proceedings are undoubtedly private. They are not always confidential. But do we understand the difference? Well, a private proceeding takes place in a room like this. And if you're in an arbitration in a room like this, the only people allowed in the room are the claimant, the respondent, their respective counsel, the tribunal, the transcript writers, the interpreters, if we've got them, and anybody else the parties choose to invite. But Mr. Joe Public cannot just poll up and decide he'd like to watch. This is a private, closed proceeding. Compare that to the court, where anybody can just decide, oh, I'm bored today, I'm going to go and watch a case. And that's a big difference between arbitration and litigation. Perhaps the bigger difference is just in terms of publicity. I practiced in Hong Kong many, many years ago now, and there was always a bit of a scrum at the court every day. If I was suing Wei Lun, I would go to the Hong Kong registry and I would take 4 copies of what was in those days called a writ of summons to the court registry, and they would put the pretty Hong Kong court seal on it, and they'd keep one for the court file, they'd give one back to me for my records, and they'd give me another one to serve on Wei Lun as a defendant. But there's the 4th one, yeah? What's the fourth one for? The fourth one used to go into a cardboard box. And at 4:30, the registry in Hong Kong would shut. All the lawyers would get thrown out. Business was over for the day. At 4:35, the court clerk would open the registry door again. And a dozen people generally would walk in. They would aim for the cardboard box that was by now in the corner of the registry. And they would start reading the writs that had been issued that day. Now, who do we think these dozen people were? Journalists. And on page 3 of the South China Morning Post the following morning, there would be a table. Every claim issued that day, plaintiff, defendant, a sentence on the type of dispute, and the sum claimed. So everybody in Hong Kong knew your business. They knew your dirty laundry. That was not a private process. That was a public process. Arbitration, subject to a bit of whispering between the people in the know, which sadly does go on, arbitration should be a private process, but not necessarily confidential. And I'm going to keep you in suspense and come back to confidential. Arbitration awards are generally binding, limited grounds for appeal. If you win, that's great. If you don't, it's a bit of a disaster. Make sure you win. But generally speaking, it's considered a good thing. So that's why arbitration's great. That's why we're all here. That's why we're all encouraging our clients to arbitrate, not to litigate. But there's a couple of common misconceptions about arbitration that I hear every day of every week. And what are those? Arbitration is quicker. Nah. Rubbish. Absolute nonsense most of the time. If you're in France, litigation's quicker every time. The French courts are quite speedy. Can't say I like them much, but it's bit rough and ready, but they're a lot quicker than arbitration. If you're in the UK, arbitration, litigation, about the same. So don't think that arbitration is quicker. Where it can be quicker is if you factor in the time spent appealing in the courts, because you don't generally have a right of appeal on an arbitration award. If you measure from starting the arbitration to the final award versus starting litigation to the final appeal, then arbitration's quicker. But it most certainly is not quicker to a judgment in first instance. And it follows from that, it's not cheaper either. Everybody tells me arbitration's cheaper. Absolute nonsense. Never cheaper. Just think about it. If you have an arbitration hearing, who's paying for the room in which the arbitrators are sitting? The parties. Who's paying for the arbitrators? The parties. If you're in court, who's paying for the courtroom? Oh, the government. Who's paying for the judge? Oh, the government again. Well, there's two costs you don't pay in litigation that you do pay in arbitration. The lawyers? Are you seriously telling me the lawyers make less money out of arbitration than litigation? Not a chance. Not a chance. Do not arbitrate because you think it's going to be quicker and cheaper. There's lots of good reasons to arbitrate. Those are not two of them. And are the lawyers to blame? Yeah, in part they are. No question. Absolutely no question at all. Arbitration was a wonderful thing when it was done by engineers and quantity surveyors and people like that. The minute the lawyers got involved, what happened? More process, more similarities to litigation, more cost. And there speaks an arbitration lawyer who makes his living out of this. Sad but true, but it's definitely true. So, those were the advantages and the misconceptions. That's about as much law as I'm going to tell you. There wasn't a lot there, was there? That's good. We're now going to go on what we see going wrong, and we're going to get into story time shortly. Enforceability, what we see going wrong, shockingly drafted arbitration clauses, often overcomplicated, often far too long. There are model clauses on the internet. Why not use them? They've been tested. They've been well drafted. Lawyers have challenged them in courts around the world. They work. Good place to start. How often do I see them ignored? Very often. How often do I see people start with a blank piece of paper and draft their own? Very often. This is what I call having your own recipe for disaster. Because the more you draft freehand, the more you are likely to get it wrong. Now, should I be complaining about this? Of course I shouldn't. Because there's one huge advantage to this approach by clients. I make a lot more money. And that's not a bad thing. Is it? No, I shouldn't say that, but it's true. It's true. Only the lawyers benefit from badly drafted clauses. Because what happens? You have a jurisdictional challenge. 9 months later, you go, oh, we can get on with the dispute now. Well, in those 9 months, you've got a hugely frustrated client who's paid some very big bills, and the only person that's benefited is me. Fascinating academic exercise, lots of fees, benefit to the client, zero. So don't get your clauses wrong. And there's one word that I live by, and I train all my associates by this: when you're drafting arbitration clauses, think about kissing. Okay? Keep it short and simple. If you do that, you will largely get it right. If you can't kiss for any reason, instruct a lawyer, because the minute it's more than half a page long is the minute it will go wrong. And sometimes you need it to be. Sometimes it gets complicated. But if you do need to get complicated, make sure you're getting it right. The few dollars you might spend on a lawyer to help you draft your clause right are a fraction of what I will charge you if you get it wrong and you have a jurisdictional challenge. It is money very, very well spent. So, lots of kissing, please. Tiered clauses. Do we know what tiered clauses are? These are clauses that say, if there's a dispute, management will have a chat about it. If they fail to agree, then we might go to mediation. If the mediation fails to reach a settlement, then we'll go to arbitration, and so on and so forth. There can be 3, 4 tiers. They all look slightly different. They're okay. I've seen them being very successful in some cases, but they do need to be well drafted. The most common mistake you see is you see people say, the parties will negotiate in good faith. Sounds good. You don't want them to negotiate in bad faith. But can anybody explain to me what a good faith negotiation looks like? I haven't got a clue. Not a clue. As long as you engage in a conversation, how is anybody going to prove you're in good faith or bad faith? Deadlines, time limits. If the dispute hasn't been settled after 30 days, whether the negotiations are in good faith or bad faith, don't care, you can move on to the next tier. Deadlines, absolutely essential. Without them, you have a major problem, because your dispute goes nowhere, and in the worst case, you have yet more jurisdictional challenges. More money for me, more frustration for you. Not good. So, tiered clauses, yes, but draft them well. Back to my favourite finger-pointing clauses. Finger-pointing clauses are, if I'm the Japanese company, you're the Malaysian company, and we agree that if there's a dispute and I want to sue you, I have to do it in Kuala Lumpur under the KLRCA rules. If you want to sue me, you have to come to Tokyo and do it under the JCA rules. So we're doing this, hence finger-pointing. Sound like a good compromise? Yeah, you can sort of get negotiating contract, substantive terms done, 11 o'clock at night or later, bloody hell, I want to go home, we can't agree Singapore, they want Tokyo, we want KL, oh, compromise, finger point. Great, deal done, contract in bottom drawer, dust gathering, dispute arises 18 months later, I dig it out, oh, God. The reason this is bad news is because if you just then start the dispute and I sue you in arbitration in Kuala Lumpur, if counsel for the Malaysian company wants to be really difficult, they think, this is all a bit awkward. I know, I'll bring my counterclaim in Tokyo. And all of a sudden you've got 2 arbitrations running in parallel, same facts. What happens 2 years down the line? Potentially conflicting awards. Well, how do you then enforce those? Well, best of luck, chaps. Is it the question of who gets there first? Maybe it is. If they're both out there, though, I can see the court struggling at that point to enforce. Again, they can be drafted to avoid that, but why bother? Why not choose one place of arbitration? Please, it's really simple. It's not that big a compromise to go somewhere else, and it's so much simpler, and it will save you so much money. And that's arbitration clauses. You think about the same for governing law clauses. If you have a finger-pointing governing law clause, and I've seen this, I would suggest to you, you have no idea what your contract means. If you have a clause that says, between a Japanese company and an English company, that says, if the Japanese company starts this, it's under English law. If the English company starts it, it's under Japanese law. Those 2 disputes could legitimately, as a matter of law, result in completely different outcomes. Because Japanese law, good faith, is an absolutely fundamental tenet of their civil code. It means something. If you ask a Japanese lawyer what it means, most of them can't quite explain it, but they know it means something. But it's there, it's sort of all-encompassing, it definitely has an effect. Good faith under English law? Not worth the paper it's written on. Barely means anything. Not quite, there's a recent-ish case which says it means something, but it certainly doesn't mean what it means under Japanese law. So you could get totally different contractual interpretations, and until somebody starts to dispute, you don't know what the answer is. That's crazy. People, you're sitting there thinking nobody ever does that. Trust me, they do it. I've seen it, time and time again. I will share with you my favourite governing law clause, and I've come across this no fewer than 3 times in 3 different contracts. Listen carefully. This contract will be governed by principles of law common to England and Azerbaijan, and if no such common principles exist, by the laws of Alberta, Canada. Now, that's one hell of a compromise. I had the pleasure of meeting the draftsman of that clause a few years ago in a bar. So I bought him a lot of beer. And after he'd drunk a lot of beer, I said, "I'm sorry, but I've been waiting 7 years to ask you this question. How on earth did you come up with this?" I said, "The England and Azerbaijan, I get it was a late-night compromise. But Alberta, Canada, where did that come from?" He said, well, we'd done the compromise and we needed a 3rd jurisdiction. So we thought, well, Azerbaijan begins with A, so it was the first legal jurisdiction we could think of that also began with A. Could have been Australia, could have been Austria. Serious, true story, I promise you. Don't do that. It's just silly. So that's clauses. Try not to get those wrong. Neutrality. Oh, sorry, we've done that as well. That's all finger-pointing clauses. Just to finish that slide, the lack of infrastructure. Choose places which have got good facilities. I'm standing in a fantastic facility. Singapore's got a great facility. Paris has got a great facility. London's got an adequate but rather ageing facility, but give them a chance, they might get there eventually. Don't go to Baghdad. Do you seriously think there's going to be good arbitration facilities in Baghdad? I don't, but a client of mine did put that in their clause, and then they wondered why they didn't have a great experience. So try and avoid that. Similarly with the courts, the Baghdad courts, are they particularly arbitration friendly? Nah, not so much. Indonesian courts? Indian courts? Well, they sort of change their minds every 30 seconds. They're getting better, but they do like a change. So Singapore, Malaysia, Hong Kong, Paris, London, there's lots of great places to arbitrate. The shopping's brilliant. Just stick with it. There's good reasons why these places are popular. So, party autonomy and procedural flexibility. Language I come back to because I've seen cases settle because people haven't put one sentence in their arbitration agreements. When you draft your arbitration agreement, and you will not find this in the model clauses from the institutions, put in a clause that says the language of the arbitration shall be, and then pick one language and one language only. So there is no debate. Trust me, if you want to try and interpret an English language contract and you have to do it through an interpreter, good luck. It's bad enough trying to interpret an English language contract in English. You try and do it once it's been interpreted into Japanese or Chinese or anything else, it just becomes a lottery. So let's put it in the contract. It's one sentence. It's not that much ink. You can afford the ink to write that sentence. Don't go with 2. The minute you go with 2, you're guaranteeing yourself a translation and interpretation nightmare. We were involved in a case, probably about 15 years ago now, in Jakarta, following an earthquake. And there was a big dispute about an infrastructure project where damage had been done by this earthquake. And there was a lot of expert evidence from seismologists and people like this. All the experts were based either in Europe or the US. All of their reports were written in English. All of the contractual documents between the parties were in English. The documents probably filled a room, I don't know, about at least the size of that table, probably more. There were a lot of documents. This was before the days of electronic review and all of that. You used to have to print all this rubbish out. So it was a lot of boxes. And we were in arbitration in Jakarta before BANI, the local institution. And surprise, surprise, day one, the Indonesians show up and go, "Oh, we're in Indonesia. This has got to be done in Bahasa." And the tribunal agreed with them. They shouldn't have agreed with them, but they did. The cost estimate for translating those documents meant the case settled. It was enormous. It was more than the claim was worth. Madness. one sentence, all of that goes away. So be careful of language. Another thing you see going wrong, you spot litigators, what I call dabbling in arbitration. That's not intended as a criticism. Everybody has to learn. I was a litigator once. I had to learn. I used to dabble. But sometimes it's blindingly obvious when you get somebody who's inexperienced, and you can take advantage of it. And at the risk of insulting some people in the room, potentially, the worst dabblers are American litigators. The word deposition has no place in an international arbitration. None whatsoever. It is a ridiculous US litigation tool that should be banned, in my view, but that's another debate for another day. But it certainly has no place in arbitration. If you have a lawyer on the other side of a case who starts talking to you about depositions as part of a procedural order, you know instantly they do not know anything about arbitration. You should use that to your advantage. They then start talking about procedural motions and things like this. They have no place in arbitration either. So when you know you've got an amateur on the other side, take advantage. It's an adversarial process. You don't have to be nice. Just make sure if you've got a better lawyer, hey, that's good news. Well done. Well chosen. All good. Another thing that I have to say irritates me enormously, and this you see from, sadly, quite experienced international arbitration counsel, and it's normally the counsel, not the clients. They play silly procedural games, often regulatory games. You see it in jurisdictions where the local bar feel threatened by the international bar in particular and try and exclude international counsel from their cases. We can discuss over a drink later whether that's a sensible thing to do on any basis, but it certainly isn't a dispute you should be having in front of your tribunal. I sit as a tribunal from time to time. That sort of correspondence irritates me enormously. It does the party making those arguments no favours, and it is incredibly rare for it to have any impact on the representation in the arbitration at all. The number of times counsel get excluded from acting based on a regulatory objection is minimal, almost never. Don't play those games. It costs money, it wastes time, it wastes your client's money and time, and it upsets the tribunal. That tribunal you want to find in your favour. Upsetting them at the beginning of the process is not a great way to start. Arbitration is a game. Rule one of the game, don't upset the judge, in this case the arbitrator. That's another theme I will be coming back to. Back to experienced arbitrators. I mentioned this earlier, but I did want to pause here, because I consider that choosing your arbitrator is the single most important step you will take in any arbitration. And it is a step that many clients and counsel take a matter of minutes or hours to do. I would suggest to you you should be spending significantly longer than that to make the right appointment. And I'll give you a few examples. When I first arrived in Japan 16-ish years ago, if a Japanese company was in arbitration and they were going to appoint an arbitrator, their instant reaction would be, must be over 70, as much white hair as possible, ideally a professor of something or other or an ex-judge. Seniority vital, might never have sat in an arbitration, might not have a clue what arbitration was. Experience was everything. Appointment made. That was the end of the thought process. There are still counsel in Japan that do that. They are fewer and further between, but it still happens. It may be, if you get really lucky, that that's the right choice. A broken clock is correct twice a day, but that's the sort of chance you are taking. You need to be thinking far harder about what the right arbitrator is for your case. And I'm going to take a few minutes just to give you a study from a matter I did about 6 or 7 years ago, which will hopefully illustrate that point without any doubt. I was acting for a Japanese truck company that had a truck distribution agreement in Thailand. The Thai company was owned by a Singaporean PLC, and the Japanese decided they were going to terminate the distribution arrangement because they wanted to put in place some new, more modern arrangements. The contract was under Japanese law, and terminating long-term distribution agreements under Japanese law is very difficult to do without paying large sums of money. So when my client terminated, unsurprisingly, the Thai/Singaporean company started a dispute. The key aspect, there was various aspects of this dispute, including some defamation proceedings in Singapore, some litigation in the Thai courts in breach of the arbitration agreement, but leave all of that to one side. For this purpose, the important part was we started an arbitration in Japan under the JCA rules for a declaration that the termination was valid. Now, we appointed a German lawyer. I'm not going to explain why, but I will come back and explain why in a moment. The opposition appointed a Dutch professor. Now, the first surprise in that was I hadn't heard of him. And I'd been doing this for a very long time, and it was a long time since somebody had appointed an arbitrator on one of my cases I'd never even heard of. So I did what all good modern lawyers do, and I put his name into Google. And sure enough, I discovered that he'd done a doctorate at a Japanese university and written his thesis on termination of long-term distribution agreements. I thought, okay, I'm beginning to understand why this chap's got appointed. So I then did what I hope all good modern lawyers do, and I put the name of his thesis into Amazon and discovered I could order a copy of said thesis, which duly arrived on my desk 8 days later. And it ran to about 115 pages, and I started to read. By about page 20, I was getting quite excited, but I had to go to a meeting. So I gave the book to my senior associate who was assisting me and said, have a read of this, and we'll have a chat when I get back this afternoon. When I arrived back, said associate was sitting waiting for me in my office. He was very, very excited. Said Dutch professor had written 115 pages on termination of long-term distribution agreements, which entirely agreed with my client's case theory. I don't think his client had gone to step 2. They'd done the Google bit, they hadn't done the Amazon bit and bothered to read his thesis before they appointed him. I then produced a submission with 21 footnotes quoting said thesis. Shortly thereafter, case settled. You really do need to do the research. It's not difficult to do in the modern age. There's a huge amount of information out there. Let's just get it done. Back to my German, never got tested. Why did I choose a German? If you look at the German Civil Code provisions on termination of long-term distribution agreements and compare them to the Japanese, the language, once you've translated them both, almost identical. The way in which the Germans interpret that language, much more friendly to the manufacturer than the Japanese. So I was gambling, if we got that far, that the German would see language he was familiar with and interpret it in accordance with German law, not Japanese law. Now, never got tested, but it was a gamble. We had a weak case. You have to take these gambles. So choose arbitrators carefully. We spend more time doing that at the beginning of a case than any other step in the arbitration. We keep a massive database of people we know, what their quirks are substantively, what their quirks are procedurally. If you want a quick process, you choose X. If you want a slow process, you choose Y. If you want somebody who's black letter law, you go with X. If you want somebody who's a bit more good faith, fuzzy civil law, you go with etc. Very, very important. Moving on. How do you become a young arbitrator? This is a challenge. Institutions very credibly are and sensibly are trying to grow the pool of arbitrators in Asia. What they're using to do that are often the emergency procedures or the smaller cases. That's a bit of a challenge because you appoint a brand new person who's never sat as an arbitrator as sole arbitrator on a small case. That's a bit of a gamble because they've never done it before. You really want to train your arbitrators as wingmen on experienced three-party tribunals, but that doesn't tend to happen. Worse still, on emergency applications, often it's the young up-and-comers that get those because they've got less conflict problems, but they absolutely don't necessarily have the experience to deal with them. The classic catch-22. I don't have an answer for that one, but I think it's something the institutions need to think about quite carefully. So, back to confidentiality. I promised I would explain what I meant when I said things aren't always confidential. And again, it's another war story. I was sitting as an arbitrator This goes back probably 6-ish years ago now. ICC case seated in Zurich. One party was German, the other party was Japanese. We had a procedural telephone conference at which the German party were arguing vociferously that they didn't want the arbitration to be confidential. The Japanese party was saying, no, it's essential, it's confidential, and this is arbitration, therefore it is confidential. Problem. The ICC rules, as I'm sure you know, don't contain confidentiality provisions. The law of the Canton of Zurich does not provide for arbitration to be confidential unless the parties have so agreed. The contract the parties have entered into said nothing about confidentiality. So we as a tribunal had no choice but to explain to said Japanese counsel that we're terribly sorry, we understood why they might think it should have been confidential, but actually neither the law nor the contract nor the rules provided for confidentiality. So as the Germans were not agreeing, there was nothing we could do. You could hear the jaw of the Japanese counsel hit the table as this was explained to them. It had not crossed their mind for a moment that this was not a confidential process. Now, that answer varies in different places. In England, the common law would save you. In various places it will, in other places it won't. But if you want to guarantee confidentiality, contractual confidentiality provisions are the only cast iron guarantee. And we see that go wrong a lot. Rights of appeal. It used to be the case that I used to tell audiences that arbitration awards were very, very difficult to set aside, and you rarely saw people bother to try. The first part of that sentence is still true. It is still very difficult to set aside an arbitration award. I would say parties are trying more and more often. And particularly in Asia, I see parties trying where a dissenting opinion has been written by one of the 3 arbitrators. And I haven't done an empirical study on this, but my gut reaction is you see more dissenting awards in Asia than you do in the rest of the world. And I'm not quite sure why that is, candidly. There's a few reasons I can think of that may be behind it, which aren't very palatable, but it's a problem. So you are starting to see more challenge, which means more cost, more money for me, so that bit's good, but generally for the process, it's not a good outcome. So just keep an eye on that. So, moving on. Other common problems, you thought I talked about enough problems by now, but no, there's lots more. Other common problems that undermine arbitration. These are very practical. The memorials are becoming absurdly long. It is common to see memorials run to hundreds of pages. I've seen arbitrators try to control this with page limits, and all of a sudden you get size 6 font, single spaced, appendix A to Z, sub-appendixes 1 to 105, all sorts of excuses to write more. If you've got a good case, you don't need hundreds of pages. You really don't. I have a rule with my associates that the longer our memorials, the weaker our case must be, and I want to know why. Yes, there are some cases which are factually complex, absolutely. And I'm not suggesting you can deal with every case in 20 or 30 pages. You absolutely can't. But when you start seeing memorials run to 200, 300, 400, 500 pages, just ask yourself, are the tribunal even going to read it? If they are going to read it, are they going to remember it? I doubt it. And it's even worse when the first memorial is 150. The defence suddenly is 250. You then get a reply that's even longer than the original statement of case. And then the rejoinder's long, and you just think, this is out of control. Memorials are supposed to narrow the issues. They're not supposed to expand them. Who's responsible? Lawyers. It's not the client saying, oh, please write more. Well, occasionally it is, but not very often. It's the lawyers. They can't control themselves. They just love writing. No. Short, sharp, summarise, bullet points, headings, all those things American lawyers never use. Full stops, they're good too. It's not difficult. And what then gets mixed into these long memorials? Oh my God, the hyperbole. Unbelievable. The use of adverbs and adjectives is extraordinary. I have another rule. I go through my associates' correspondence and I cross out every adverb and adjective I see. I do not want to see them used except in exceptional circumstances. If I'm sitting on a tribunal and somebody says they were in breach of contract and somebody else says they were in outrageous breach of contract, does it mean anything different? They were either in breach or they weren't. Do I care if it was outrageous? I mean, if you're taking, also argue material breach, there's language you can use, but really? Does it add anything? No, it's just colour. Makes the lawyer feel better. Perhaps it makes the client feel that the lawyer's on their side and they're really taking it seriously and they're arguing really hard. I'm sorry, grow up. Don't use them. We play bingo. We play adjective and adverb bingo in hearings, where certain counsel have favourite phrases and words they use throughout their pleadings. And I sat in a 2-week hearing in Singapore last April, and we had 5 lawyers in a room for 2 weeks. We had bingo cards in front of us, which had all these favourite phrases taken out of the opposition's pleadings on the top. And the first one to tick them all off in the day got a prize that evening. Every day we had a winner. Every day. It was it was great fun. It was a dull case, and it cheered us up enormously. Really? It's just out of control. I'm sorry. Alongside that, quantum. Oh boy, do clients love a quantum claim. If the claim's worth 10 million, oh no, we should claim 100. Yeah, that's a really good idea, because we'll look so credible. Really? You then get an expert who says it's worth 5. Okay, how are we going to argue this? Oh, no, we've got to claim 100, because it's going to settle, and this is our negotiate. Yeah, right, it's going to settle, but it's not going to settle for 100. If it's worth 5, it'll settle for 5 or less. It's not going to settle for 100 just because you claim 100. Just think about the reaction of the tribunal. The tribunal see a claim, they know you've got a liability claim, and then they see you claiming some silly telephone number. Frankly, all they probably think, certainly if they're sitting on the ICC rules, is, oh, that's good, I'm getting paid more. Because the ICC fees have just gone through the roof. That's the only tool I know that controls clients from adding silly numbers. If you've got a good claim, be confident about your claim, but be confident about a sensible number. And don't think, oh, well, I've got to negotiate it down by 75%. If it's worth 50 million, keep telling them it's worth 50 million and settle for 50 million. You don't have to claim it's worth 500. You just look like fools. You lose credibility, it weakens your position. So please don't go there. And on a similar note, every case has a weakness somewhere. I don't think I've ever done a case where there hasn't been a problem. There's always a problem. Deal with it. Don't hide from it. If you raise it and deal with it, the tribunal think, oh, okay, he's recognised that and he's made a good argument and that's all very sensible and, yeah, I agree. If you wait for the defendant to raise it, they'll be thinking, oh, well, okay, he was trying to hide that, so maybe he's worried about it. And I better look at it a bit harder and, oh, well, this guy might have a point. I think I might have to ask a few more questions. Why make life difficult for yourself? Just put it out there. Knock it off. This is a game. There are rules of the game. You follow the rules, you win. You start messing around, more often than not, you either lose or at the very least you cost your client an awful lot of money. So short memorials, leave out the adverbs, leave out the adjectives, sensible quantum claims. God help you if you can find a good expert. Let me have his number. These people called experts, in my experience, are often not very expert. It's a bit of a misnomer. It's quite challenging finding a good expert, whether it's a quantum expert or a liability, whoever it may be, it's really quite challenging. So if you find a good one, please pass on the details. Other procedural steps that get abused, disclosure. There's always a bit of an issue between civil lawyers and common lawyers here. Common lawyers are used to disclosure. American lawyers are used to warehouses full of it. English lawyers are full of small rooms full of it, but they are used to some documents. Civil lawyers are used to almost no disclosure. Japanese lawyers look at you blankly and think, disclosure, what's that? What do you mean I have to produce documents that don't help my case? I've just shredded those. I mean, it's just, you then get into arbitration, and most of arbitration is done under the IBA guidelines. The IBA guidelines, in my mind, provide for disclosure that falls somewhere between the civil law none and the English law small roomful. And I think they're quite sensible. The problem you have is if you've got civil lawyers on the other side, they will happily agree to the IBA rules, but they won't necessarily interpret them in quite the same way that a common lawyer would. And then you have big arguments about what amount of disclosure was appropriate, whether they've given proper disclosure and all the rest of it. Very difficult to deal with those arguments, other than asking the tribunal to draw adverse inferences for failure to respond. It wastes a lot of time. When you have the procedural hearing, talk about disclosure. Don't just agree the rules, talk about what they mean. Try and raise the level of understanding in the room. And I say that to you if you're sitting as an arbitrator or if you're sitting there as counsel. It is in your interest to have a common understanding of what the order means at the beginning. And I see that misunderstood a lot. And the fact that the arbitrators don't have a lot of sanctions to deal with it makes it very difficult to deal with it once the problem has arisen. So try and nip that one in the bud early. Oh dear, we're back to one of my favourite hobby horses. Witness statements. Submission, 50 pages. Witness statement, 550 pages, because they've stuck the rest of what they wanted to write in the memorial in the witness statement. No, that's not what the witness statement is for. You then get counsel who think it's entirely proper to have written a witness statement, often a long witness statement, and then spend hours at the hearing supplementing that witness statement with stuff you've never heard of before. That's not how it's supposed to work either. You need a strong tribunal to stop it happening. It's again quite difficult to stop it happening. But probably more problematic is seeing lawyers too involved in drafting witness statements. Yes, it is the norm for lawyers to hold the pen, but remember, it is the client's witness statement. They are the witness, it is their words, it is their understanding. Back to the case where we were playing bingo in Singapore, we had a wonderful moment in cross-examination of one of the opposition's chief witnesses. We were having an argument about what a particular clause in a contract meant. This contract had been through about 4 drafts before it was finally signed, and all of these drafts were in evidence. And the opposition's witness had written a statement in which he had said, in terms, in each draft, the terms of clause, I think it was 8.2 or whatever it was, were italicised and in quotes, identical. So, interesting moment in cross-examination when we produced clause 8.2 from draft 1 and asked him to read it. We then produced 8.2 from draft 2 and asked him to read it. And, oh, hang on a moment. That seems to be slightly different, sir. Oh, yes, it is. Draft 3, different again. So, when you wrote in your statement that the 3 drafts in clause 8.2 were, quotes, italicised, identical, exactly what did you mean? You could hear the silence in the room. I can tell you which lawyer drafted that statement, because there was a chap sitting across the road from the other firm's solicitors, who, as we were asking his questions, was doing this with a piece of paper. And as we asked each question, it got tighter and tighter. And when we moved on, he just went, that's who drafted that statement. It was not that gentleman. My client turned to me and said, if you did that to one of our senior executives, you would be fired. I have to say, I agreed with him. It was outrageous. But you see it happen time and time again. Not often as blatant as that. The lawyers get too involved. The witnesses aren't encouraged to read the statements and take responsibility. The credibility of that witness from that moment on was 0. There was a waste of his time saying anything else. The tribunal were not going to believe a word he said. Be very, very careful. So, lots of problems. How am I doing for time? Well, we've got a few minutes. I'm going to change tack slightly. It is possible to keep your tribunal happy. We'll not do that. Here we go. I said earlier it's a game. The tribunal is your friend. The arbitrators are people you want to find for you. So what do you think you do to make them find for you? You make their job simple. You make it easy. You make the arguments that they understand and they might wish to adopt. You help them with the maths. Lawyers aren't very good at maths, so they like to be helped with the maths. You try and draft the award for them. Drafting arbitration awards is a very time-consuming process because arbitrators are terrified of having their awards challenged, having them set aside and then never getting appointed by anybody else ever again. So they spend hours trying to get these things right. So if you're counsel, draft it for them. Not the whole thing, but the key arguments. Just put it in language they can cut and paste out of your memorial into their award. If you've done a really good job, you pick up their award and you think, this is all looking very familiar. Well, it is, because you wrote it. well done, good lawyering, excellent job, happy client. So keep them happy. But at the same time, you have to balance two things. By the time you get to a hearing and past a hearing and the arbitrator's writing that award, you will think he knows a lot about the case. Never forget how many hours you and your team have spent preparing that case. You will understand that case on a completely different level to even the best arbitrator in the world. That is an absolute given, because you'll have spent hundreds of hours with your team mithering over the details. The arbitrator will have heard about it for maybe a week or two in a hearing. They're never, and they probably haven't read your 800-page memorials. So you have to understand, you understand it better than they do. That, if you're not careful, leads you to treat them like idiots. That's dangerous. These people are very intelligent. They're not idiots. They just haven't spent the hours that you've spent. So there's a real delicate balance between telling them what they need to know, but treating them respectfully and making them think that they've come to the answer, they haven't been spoon-fed. I can't tell you precisely how you do that. It's a skill that you sort of pick up and massage along the way, and it depends from arbitrator to arbitrator. But it's very important you get that balance right. If you treat them like buffoons, they're less likely to find for you. Part of that is looking at the arbitrators during the hearing. Listen to them. You need to think how they react. You need to also be careful not to overanalyze, because we're not mind readers. Sometimes an arbitrator will sigh because he's tired, rather than because he thinks your case is a load of rubbish. So you need to be careful you're not reading too much into the reaction. But normally, if you listen to the questions they ask, you get serious clues as to what they're thinking the weaknesses of your case are, the strengths of your case are. You need to read those and pursue them, because they might think something's really important that you were going to gloss over, or vice versa. If you waste an hour talking about something the tribunal's hinted at in their reaction they're not interested in, you'll just bore them and they'll lose interest and they'll stop listening when you get back to the important piece. So you need to watch their reaction. Welcome their questions. I like arbitrators who ask a lot of questions because it gives me a lot of clues. When they ask a question, try not to say, I'll come back to that. I think if you went through the transcripts of most arbitrations and counted the number of times a counsel said, I'll come back to that, and then the number of times they've actually come back to it, probably about 10%. People forget to come back. Seriously, they just forget. Sometimes deliberately, because they don't have a good answer, and that's the inference the arbitrators draw when you forget. So be very careful. But also, this is just too obvious for words, but it happened in a real case. I was sat in a case in Hong Kong about 18 months ago, and an arbitrator was asking counsel for the other side a question. And the counsel's response, as far as I can remember it, was, "Thank you, sir, but I'm not interested in your opinion." I thought that was an interesting approach. Not only was it rude, but that's the guy that's going to decide your case, and you're saying you're not interested in his opinion? The only thing you should be interested in is his opinion. His opinion is the answer to your case. Don't do that. Really not a good idea. And in the modern world in which we live, the other thing that you see a lot, technology. Some lawyers love technology. Technology has its place, as it does in every part of society. You overdo technology, and you lose traction with the tribunal. If you use it well, it can be incredibly powerful. If you use it every 5 minutes for every point, they switch off. So if you're going to use something whizzy, you've got something you want to put on a screen, some video you've made, just think carefully. Do I really need this? What impact is it trying to have? Can I do it in another way? Is this the most effective? If you ask yourselves those questions and you still think, yep, I want to do this, that's fine. But sparingly, not too often, I would suggest. I think we're on to questions. Thank you very much.
Thank you, Peter, for a really entertaining session. I did not have a chance to read his slides. I only went through with with all of you when he was giving his presentation. I must say, and I'm convinced after his talk, that he really has set out the essence of the good, the bad, and the ugly of the arbitration. One observation that he has made is about arbitration being private, but not necessarily confidential. I just want to add one more point, that is that in Malaysia, if you go through the Arbitration Act 2005, there is no provision for confidentiality in arbitration. Yeah. So in order for, if you really want confidentiality in arbitration, I think you have to take Peter's suggestion. You better put it in the contract, in the arbitration agreement itself. Okay, it's Q&A time. This is really a very rare opportunity that you can seize, that you have Peter Godwin, who has vast experience in arbitration in Asia, as you can see from his profile. Please, if you have any question, feel free to ask. Anyone? Okay, yeah. Pass you the mic. Oh, all right. Please identify yourself before asking the question.
Nick White, Trowers and Hamlin's the one and only foreign law firm in Malaysia. So that's the advertorial done. Peter, thank you for that. Very entertaining. Part of your talk focused on the importance of getting the arbitrators right. And of course, if you've got a three-person tribunal, the parties will jump in and they'll fix one each. But they can't agree on the third. So the arbitration institution may step in and pick. Or if it's a one-person tribunal, they may pick. What good, bad, and ugly experiences have you had in the region where the institutions have had to pick the chairman or the sole arbitrator?
Yeah, that's a very good question, Nick. You're right, you do not always have enough control. I think the first thing to say before I get on to the war stories is certainly where you're seeking to appoint the chairman of a three-party tribunal, although the institution will ultimately make that appointment, it is possible to agree processes with the other side to influence that choice, to understand what attributes you want the tribunal chairman to have. Sometimes you can agree mechanisms to have a short list of candidates and they will pick from that. So you don't lose complete control sometimes. And even with a sole arbitrator, you can sometimes agree some of that, and I would encourage you to do so. The more control you have, the better the outcome. If you are left in the hands of the institutions, pop down the casino, stick your chips on red or black, because it's a lottery. It really is. I had a case in Bangkok a few years ago before the ICC. The ICC generally recognised as the most venerable of arbitration institutions who know what they're doing. They appointed a 78-year-old English qualified Thai national as the arbitrator. The process was painfully slow. I'm not sure he'd ever done an arbitration before. But the worst part of it was once the process was over, we had a very, very, very long wait for the award. Eventually, after 18 months of waiting and still no award, I had a conversation with my client about whether we needed insurance in case he died, and we actually had to start over again. Fortunately, after 21 months, he finally issued an award, and the relief was palpable because we genuinely thought we might never see one. So that was one poor experience. I think others, you just see not the best choices made. I think there are some countries around the region, and I would include Japan in this, about which I know quite a lot, where the pool of arbitrators that get appointed by the institution, whether the ICC or the JCA, it's a closed club of 4 or 5 people who look after each other. Frankly, those people, with limited exceptions, are not the best people for many of the appointments that they get. So that's pretty disappointing. You see that in other jurisdictions as well. Other times, they try their best, they just frankly get it a bit wrong. An institution will never spend as long as I spend looking at the background of arbitrators and deciding who's the right person to appoint. They will usually have a relatively short list. They will take account in broad terms of the parties' views, but ultimately they'll want to make an appointment quite speedily, and that's what they'll do. Sometimes you get a good one, other times you don't.
suggest the parties to, or you can talk to the counsel to agree on a list procedure. Perhaps you can ask the institution to provide a list of arbitrators, and with that limited number of arbitrators suggested by the institution, then both parties can try to agree to a common agreed person.
No, certainly if you can, any process like that is better than leaving it solely to the institution, and certainly experienced counsel will always try and agree at least a process, if not an individual.
I have a question. My name is Susila. Regarding the appointment of arbitrators, you mentioned that one approach would be to do a search on the internet. In your experience, have you attempted to interview potential arbitrators, and what are the do's and don'ts in such a process?
Yes, interviewing potential arbitrators is becoming more common. The don'ts are you can't talk about the facts of the case you're looking to appoint them to, for obvious reasons, because you'll be seen to be influencing them, and then they'll exclude themselves. So you have to talk. You can talk about the legal principles in broad terms that might be coming up. You can talk about their background. You can interview them in relation to their procedural preferences, and you get a feel for the person, but you have to steer well clear of the facts of the case you're actually about to argue in front of them, or they will end up having to exclude themselves for conflict reasons. But you do see increasingly people interview arbitrators prior to making that appointment.
I think CIRPA has a protocol for interview of intended arbitrators. What you need to do is that you have to record it down, the conversation between the interviewers and the interviewee, the potential arbitrators, so that, to clear any doubts as to his impartiality or biasness at the later stage of the proceeding, if he's chosen as the arbitrator. Any further questions?
Yes. Thank you. John, my name is C.K. Koo. I have two very quick comments and followed by two questions. I'll deal with the two short comments first. The number one point, you mentioned about KISS. I think that's very good advice. And what I came across about KISS was many years ago when I was attending a course in UK. It was mentioned that there was an arbitration agreement which simply said, arbitration, London, ICC rules. I think the validity of that clause was taken to the English court, and the English court upheld it and said that that was a valid arbitration clause. So that's it. Then on what you mentioned about interpreters, my experience with interpreters has been quite disastrous. We had a witness in one arbitration in which a witness could only speak in Chinese or Mandarin and not English. So we had a court interpreter come in to do the interpretation. Now, as I said, that was a complete disaster because it didn't last very long, because every time he made an interpretation, there were times when, well, I do understand a bit of Mandarin, and some of the people, the witnesses and counsels on both sides, also understood what was being said in Mandarin. So when the court interpreter interpreted into English, almost in unison, myself and the people who know Mandarin, that's not what the witness said. And that's it, and that was the end of the interpretation. Now, questions on, you mentioned a case or cases in which different laws were put into the arbitration agreement. I presume that is law of arbitration and not the substantive law. Could be both.
Unbelievably, it was a substantive law.
Substantive law,
yeah.
Okay. Okay, in that case, my question on that would be, could this not have been dealt with in the arbitration by the conflicts of law rules?
Well, no, because depending on which arbitration was started by which, if it was an English company and a Malaysian company and the English party had started the arbitration, then they would have chosen Malaysian law. If the Malaysian company had started the arbitration, the clause would have chosen English law for them. So until the party actually filed the request for arbitration, you didn't know what law applied. Now, my basic understanding of English law and Malaysian law is there's a lot of similarity, probably wouldn't have mattered. As soon as you get a common law and a civil law, again, 99% of commercial cases won't make any difference, but just occasionally it does. So best avoided. It's not difficult to say the law of the contract shall be and then you choose one law. It really shouldn't be that challenging, and that's the right answer.
And finally, the case that you mentioned in which the Dutch professor was appointed as a co-arbitrator or chairman, and he had written an elaborate thesis on the very subject of the arbitration. Now, could not a party have disqualified him for having preconceived ideas and bias?
I think in that particular case, his thesis was 20 years prior. So it's not as if he'd been writing on it every week of every month for his entire career. He just happened to have done it when he was a student. And they had chosen to choose him. I mean, once I saw his thesis, there was no way I was going to apply to disqualify him. I was delighted they'd appointed him. If they'd had any sense, they would never have appointed him, so he would have been disqualified in that way. But it's difficult to get arbitrators disqualified, and certainly unless they've written extensively on a particular subject and have really pinned their colours to a mast, at the end of the day they'll say, no, I'm a professional, I'm impartial, I'll decide the case on its facts. So that's rarely a ground that you can successfully use to challenge.
Do you have any question? I'm sure you have some questions in mind being formulated. Anyone else? Any problems you're encountering in your arbitration? Yes? No?
Can I ask, what's the biggest complaint anybody has in the room about arbitration? Is it cost? Is it time? Is it inability to get the right lawyer, the right arbitrator? What are you finding most challenging?
Yeah, and time. Yeah, I think the most important thing is, as you said, must set the time limit, then you move on to the various tiers, you see. I think time is quite important because, as you said, if you want claims, you want to settle as fast as possible, time is cost to them, you see. So that is my opinion, and share whether you could agree with that.
No, I definitely agree with that. I think lawyers have got a lot to answer for, I'm afraid. They write too much. They agree procedural timetables that are too long because they worry about their holidays and things. We need a few more strong clients who say to them, no, this has got to be done in a year. I want you to design the timetable in a year. I want you to agree short memorials. I don't want you to go fishing for discovery. And even then, it's difficult because you need both clients to be saying the same thing to their lawyers, and that rarely happens. But the process is out of control at the moment. And unless we fix it, I think the arbitration community is in trouble because the world will find a better way of resolving its disputes.
Recently, I read an article published in the CIAB journal by Samantha Rowe and David Rifkin, if I'm not mistaken. In the article itself, it quoted a research a survey done by Watt & Case in 2010, and they said that one of the main contributors to lengthy arbitration or costly arbitration is actually the problem is attributable to the lack of control or experience by the arbitrators. What do you think about that, Peter?
I think the arbitrators do have a part to play in this, but they ultimately have very few tools in their toolkit to really sanction parties. And the the only way you can really challenge an award is procedural unfairness. And tribunals are terrified about imposing too short deadlines on people when parties are arguing vociferously they need longer, because they fear that they will be challenged. And only the most experienced arbitrators are prepared to take that risk and be fairly robust. We need to encourage more arbitrators to go down that route, but it's a difficult thing to do. Because there's no rule book that says this is fair and that's unfair. It's always case by case, what's reasonable, what isn't reasonable. But it would be not the one advantage court judges have is they do have some real sanctions they can apply, both in terms of costs, in terms of what we call unless orders and this sort of thing. The tribunals do not have those tools in their toolkit, and unless we give them some, I fear there's not an awful lot they can do.
A while ago, is really an interesting subject, and we can actually see more people are willing to adopt this multi-tiered arbitration clause nowadays, seeing that the cost, not only in arbitration, I think in litigation as well, can be quite costly. So as much as possible, if they can actually resolve the disputes through other forms of ADR, I think they are more than willing to do that. What is your experience in so far as, or the problems relating to the adoption of escalation clauses or multi-tiered arbitration clauses?
Tiered clauses can, as I said, can work very well. If you look back to the Hong Kong airport development back in the mid-90s, all of those construction contracts had 4 tier clauses in, everything from negotiation through to senior management discussions, mediation and arbitration. There were well over 100 disputes arising out of that project. Only 2 went to arbitration. All the rest settled a number of the biggest ones at the mediation stage. So it can work very well. The key to it is to draft it well so there are clear deadlines for each stage. But for smaller contracts, I would encourage you to ask yourself a few questions. The first one being, is it worth drafting into your contract that you need to have a period of negotiation? I've been doing this for 25 years. I've never had a dispute where there has not been a period of negotiation between the parties before a formal dispute mechanism has started, whether or not it's been written in the contract or not. So by drafting it, I just think you're risking drafting it badly and causing yourself a problem. So personally, I would always skip step 1. I think the senior management discussion is often effective, but again, doesn't that usually happen? Maybe, maybe not. So I can see that. Mediation, I think, is growing in popularity. That said, don't buy the statistics you get from the mediation centres. They will tell you about these huge success rates. Well, yeah, most cases do settle, you're right. Whether the mediation's helped it settle or not, maybe. Sometimes it does. I've seen mediations that have been complete car crashes. The risk with mediation is unless both parties are committed to settlement when it starts, it will fail. If it's going to fail and one party has gone in bad faith knowing they're never going to agree a number, they can use it as a rehearsal for the arbitration to find out what your case is and to help them prepare their case against you. And I've seen that tactic used repeatedly, and you need to be wary of that. So mediation, yes, but just be careful. And then you get to arbitration. So tier clauses, I think, have their place. I just think there's a sort of slight sense that they should be the norm, and that's not quite how I see it. I think they're right, particularly in the construction industry, I think they absolutely have a place. In other industries, I think it's an overcomplication that's unnecessary.
Arbitration clause is this. Because there's a recent decision in Malaysia that until you file in a notice of arbitration, time hasn't stopped running. That is a limitation period for commercial cases. So according to our limitation statute, is 6 years from the date the cause of action arose. So if you are facing a situation whereby there is a multi-tiered arbitration and each step has got a timeline and you can't go straight to arbitration unless you have actually gone through the pre-steps to arbitration. So how do you actually resolve? Is there a way for you to deal with that problem? Because if you were to go through the pre-steps completely, then you will be out of time when you have the right to commence arbitration.
Yeah, I mean, it's a very good question. I mean, one would hope that 6 years is long enough in most cases, but I accept that it won't always be. I mean, I don't know whether there's a legally tested answer to that. I certainly haven't come across it, but if I was faced with that situation, acting for a client, I would file the arbitration anyway, stop time running, and then seek to agree a stay of the arbitration whilst the other steps in the procedure were followed, and then if it hadn't settled, go back and reactivate the arbitration. I would be amazed if a court in any sensible jurisdiction were to find that any sort of abusive process. I think they'd consider that entirely sensible and normal behaviour. So, but I think you just have to keep an eye on it and make sure you've done it.
I do not know the answer. Would filing an action in court in breach of the arbitration agreement a way to deal with this situation? Because as you know that when you file an action in court, the other side, if they want to insist on complying with the arbitration agreement, they won't actually apply to strike it out. They only apply for the matter to be stayed pending reference of arbitration, meaning to say that the case is already filed in court and it has stopped the time from running. And then if the other side is actually asking you to comply with the arbitration agreement, then you will have time to go through the pre-arbitration processes and then go on to arbitration. I don't know whether that works.
I think it's as likely to work as my suggestion. I think they're broadly the same thing. But if you've got a procedure which ultimately leads to arbitration, my inclination would be to start the arbitration if that has the effect on limitation. I think that's likely to be deemed by the court to be the more prudent approach, but your route may well work as well. You can take one to court and find out for me.
Anyone? Any further questions?
So in your experience, have you come across a case where halfway through the arbitration, it was abandoned, then they will go for liquidation?
That's an interesting question. No, I think it's a short answer. I mean, certainly there have been cases which have started in litigation and ended up in arbitration, not just because there was an original arbitration clause, but the parties actually agreed they'd rather be in arbitration, so they entered into an arbitration agreement subsequently, which is very unusual. I don't think I've ever had one that started an arbitration and the parties have decided, actually, no, we'd rather litigate. I can't think of one off the top of my head.
Question, then I think we can close the session. Thanks a lot, Peter. Thanks a lot.
Thank you, Peter. Thank you, Wai Lun. And before we conclude, on behalf of KLRCA, Wai Lun, if you could just honor us in presenting a token of appreciation to our speaker for his excellent presentation. Ladies and gentlemen, can we please put hands together for Peter Godwin. Just 1 second. Yeah. And Wai Lun, on behalf of Tusundra, thank you so much for moderating this evening session. And on that note, thank you, ladies and gentlemen. Till the next time, do take care.